personal views and opinions expressed by our podcast guests are their own and are not legal advice or official statements by their organizations. Hello, my name is Debbie Reynolds. They call me the Data Diva. This is the Data Diva Talks Privacy podcast, where we discuss data privacy issues with industry leaders around the world with information that businesses need to know now. So I have a special guest on the show all the way from San Juan, Puerto Rico, Roberto López-Dávila. He is a legal advisor at the General Court of Justice of Puerto Rico. Welcome.
It's a pleasure to be here. So finally having this great opportunity, mostly because you are someone that I admire so much. So this is really a dream come true to have a chat with someone that I admire so much in the private field. So it's a great honor.
Thank you so much. I'm so excited to have you on the show. We've been trying for months to get this together, and we finally did, and I'm really excited. I love to talk with people from just all over the world, and I know you have a very unique perspective. I follow all your stuff on LinkedIn. You always have smart answers, and then also at some point we're going to talk a bit about AI, because that's an area that you're also interested in as well. So tell me, how did you come to your career, and how did you develop an interest in privacy?
Well, I am a Gen X person, so I began my career just at the dawn of the 21st century. So this is all .coms, all these enthusiasm with the web and so on and so forth. And then a public debate with regards to the possible relationships between law and technology. And I get fascinated, at the very moment that this debate began with, that important book by Lauren Lessing, and all this, that conversation that started with him just blew my mind. And I knew at that moment that I have to, have a very, not only to become part of the conversation, but in order to do that, I have to get the fundamentals. One of the most important aspects that this new relationship between law and technology was generating was with regards to privacy. Major issues that began to surface as a major aspect to take into account, particularly when we deal with rule of law, fundamental values, the importance that we as a society, at least from the Western Hemisphere, gives to privacy as a fundamental right, or at least as something important for a civilized society and a civilized life for all of us. So I began to see the work that the International Association on Privacy Professional was doing. At that moment was just at the early steps, and then began taking the certifications of the association in order to get really involved in the debate and the conversation, and also to help my current employer with all the privacy and cybersecurity issues that we were confronted as part of their modernization efforts at the judicial branch.
Yeah, I want to talk a little bit about that. So you've been with the General Court of Justice in Puerto Rico for almost 19 years. So when did privacy, at what point did privacy start to creep up where you say, okay, I need to really pay attention to this in technology?
That began when we started to think about put forward a justice initiatives. I not only because I was seeing all the problems and the gaps that we began to see while we were crafting all the projects and so on, but also because I was doing a lot of studies of what was happening in other jurisdictions. So in that way, I had the opportunity to see things that we have to tackle early on in order to avoid a lot of the problems that different jurisdictions were confronting within their e-justice digital transformation efforts. So it began in that realm, and it was while we were involved in all these projects, or currently have an electronic case management system running, and also e-file, e-notification platform and modules that are working pretty well, not in all of the subject matters, but most of them, particularly in the civil field. So I then it begins to transform and began to see that we have not only to have awareness, a privacy awareness, but also to develop some kind of practices within the way that the courts have to operate. So in that way, we realized that we had to modernize or update our document management practices, and also the document and data retention process. Recently, in the past during the past months, the Supreme Court, which is the main governance body of the courts in Puerto Rico, approved a new data retention and document retention regulation, which not only deals with the different schedules for document retention, but also include some data management practices that we believe were critical in order to have a preventive, more controlled approach to how we deal with data and documents, taking into account the importance that they have for the judicial process as a whole.
Yeah, right. That's fascinating. So that's great. I love that you guys are doing that. So I guess there are two parts to that. So one is this is the way that we think that people should handle themselves going forward, but then also you're adding more of a proactive approach to it as well. So like this is how, so this is what the rule is. This is what happened. Like if you don't follow the rule, but in order to give people guidance, you added that to your regulation as well. Like saying, hey, this is the way that you should, organize yourselves around data, correct?
Yes, we have another challenge in that regard, and that is that we as a jurisdiction, Puerto Rico is, as you know, is a U.S. territory. So some U.S. laws applies to us directly, others don't. So as part of the U.S., we ensure that, let's say, we don't have that data protection tradition that other countries, have. As countries from Europe has a more robust data protection background. We don't have that. So that means people know that their privacy is important. In fact, privacy is a core value for Puerto Rican society, is enshrined in our Constitution as a fundamental right. But theirs haven't translated, at least yet, to a comprehensive law. So that reflects the importance that data protection has as a projection of privacy as a fundamental value. So we have that challenge in the sense that people do not have perhaps this tradition of having this to guide their behavior through certain principles of data protection, or at least the awareness that perhaps other countries have. So the judicial branch has, that means that the judicial branch has a tough job to do in that regard, because you have to compensate for the lack of or a robust culture with regard to data protection. But this is something that we as a society, as a Puerto Rican society, has to deal with. We have suffered a lot of cyber threats, cyber attacks, cyber events, particularly including in the public sector. To my mind, because we haven't had that, haven't given privacy and cybersecurity the importance that it requires. We are right now trying to, as a government, trying to do a better job in that sense. But what I wanted to say is that it is a little bit more difficult when you have a society that doesn't have this robust background from a data protection perspective. So we have to work even harder to make sure that we got this right, because this data is everything when it comes to the judicial process. After all, we are moving data from point to point. Lawyers file suits, they file actions. That action transform into a process. We add information. The other parties in the case add more information, and then all the judicial operators begins also to add their part to the process. So it is a lot of information that we have to deal with, and it's the core of all the judicial process. So we have to adopt some sort of fiduciary attitude to as a custodian of that important data.
Oh, that's interesting. This is fascinating. Okay, so this is cool. I didn't know that Puerto Rico had privacy as a fundamental human right in your constitution, which is great. So I would love for the US to have that. But you're right. So there are gaps there, right? So it just can't be a feeling of privacy. You want to be able to have some meat on the bone, right? Around how people can protect privacy. And so the technology always outpaces the law. So you're always kind of trying to pay catch up on the law. But I think you hit on a really interesting point, and that's around kind of education and also understanding that, our country hasn't had the same experience, for example, as Europe. Because I've heard people say, why don't we just take the GDPR and put it in the US? And like, I see you're laughing about this. It's like, yeah, that actually, we're just different countries. We have different foundations. I think one really interesting thing, and I want your thought about it, is that, and you've done it very well by talking about data protection, right? Because people in Europe, sometimes they get upset when we talk in the US, we talk about data privacy, because for them, they have privacy as a fundamental human right. So all they're trying to do is protect the privacy that they have. And we're trying to get privacy as a fundamental human right. And then we're trying to protect it at the same time. So what are your thoughts about that?
Well, this is the traditional conflict. U.S. liberty, Europe fundamental rights. This is something that, in some respect, I am beginning to see that is a little bit unjust with regards to the U.S., because a lot of what has been the evolution of privacy as a concept, including as a human right, has been developed in the U.S. Besides the typical reference to the Brandeis Warren law article, which is a seminal article, it creates a new field in a new law field. So it's a big event for law in general, but in particular to privacy law. But also you have to take into account that a lot of principles that we take for granted were developed during the 1970s in the U.S. in the form of the Third Information Privacy Principles, which are the basis of the UACD guidelines and even the Convention 108 in the Council of Europe. So there's have been a strong influence in a lot of the things that we consider right now as a standards from a privacy perspective. And also we have to take into account that despite the fact that as of today, at the moment, the GDPR seems to be the standard and probably will remain the global standard or the one that a lot of countries look to in order to craft their own statutes. The work that California has been doing, as has been, the case for a lot of things that a lot of law that had to do with technology, it's really amazing. When you see the CCPA as amended, it's mirrored in a lot of ways and even goes beyond the GDPR. Take for instance, the in the definition of personal data, they include as part of the definition inferences drawn. This is a major development, and this is not even, at least as of today, it's not recognized within the GDPR. So it's we have to. It remains to be seen how this statute is applied, because there's a lot of struggle with regard to in the event that the PDP the American Data Privacy Protection Act is finally approved, and the preemption debate that is currently going on, if in fact it will preempt states, regulations, including a robust one as the Californias. But probably, there's as laboratories of democracy, states have been doing a lot of work and creating model for the rest of the nation in different things, but in particular when it comes to technology regulations. And this is another instance of that regard. So at the end, I mean, I guess I know the U.S. has to learn a lot from other jurisdictions, and in fact, I believe it has learned a lot. Probably all the impetus that we are sensing from the U.S. from a federal level has to do with with the pressure that it has beginning to sense, not only from Europe but also from China, has recently has also been active in the regulatory field with regard to technology as well. But perhaps we have to be more just, to my mind, with what has been the role from the U.S. and its contribution to create standards and provide basis for regulation all over the world.
Yeah. I think you're right. And it's interesting that you mentioned that. So I had another podcast guest recently, Cameron Carey, who's at the Brookings Institution, say the same thing that you just said about the Brandeis article and the fact that, creating kind of this whole new theory around privacy in the U.S. and also the U.S. leading privacy and being very influential in the early 70s. And then kind of sort of where we are now is very interesting. I think, like you said, I love the way you said it about, having privacy in these different locations develop as kind of like laboratories of democracy. And so, we do have a issue now with, states' rights in the U.S., rights and territories, as you say, federal rights, figuring out what we want to do on a national level. I think that's really interesting. And the two things that always come up are preemption and private right of action, which people fight about. I don't think people are going to ever stop fighting about that. But one thing I want your thoughts on, and this is another debate that people have a lot around privacy laws. So, like, for example, U.S. laws, in my view, tend to be very prescriptive, where like the European privacy laws, in my view, tend to be more, less prescriptive, right? So, like for example, GDPR, and this is so funny because I have people who dislike, either for different reasons. So, I have people who, like me, say I like GDPR because it has these broader concepts like privacy by design and stuff like that. And it's sort of incumbent upon the organization to decide how that works within their organization, right? Where we have something like California with the CCPA saying like put a button on your website that says this exact thing. So what are your thoughts about that dichotomy of kind of like the broader concept versus like, we're just going to tell you exactly what you need to do and be like very specific?
Yeah. Well, I guess this is one of the instances where you see the different traditions reflected in the way laws are rendered in both sides of the pond. So I guess that when the technique employed by the Europeans reflect the human right based approach that they have to for laws. In particularly in this case, the human right roots for data protection. That's why they place a lot of emphasis on principles. You have all these, this principle of lawfulness, fairness, transparency, purpose limitation, storage limitation. So, and they began to create rules around those principles. In the U.S. case, probably they are more trying to give more. They believe that probably if you approach regulation in that way, will hinder some initiatives, or people will not understand what you should do. It will be more difficult to translate those principles into actual practices. So, in fact, that's one of the, I don't know if we should call it a problem, but it's a challenge to see how you translate those principles into actionable practices. When it comes to the enforcement of GDPR, it's very difficult. There's a lot of issues that are open, and that's why has been a lot of opinions and reports from the European Data Protection Board and the former 29 working group, because there's a lot of gaps on how we translate this into something that is more concrete. So, and this is something that, well, it goes with the regulation. We are, as a community of professionals, we are trying to understand how to make this operable. And how to enhance the law, in its enforcement. But if you notice, there has been some sort of cross-fertilization experience between the two blocks. Not only because we are taking the U.S. is taking drawing from the principles and aspects of the GDPR and other similar regulation into their own, but also it is reflected in the fact that, for instance, now there's a tendency to call all, or at least some of the regulation within the European Union domain as act, and as the case of the AI Act. There's there has been some sort of cross-fertilization experience between, and this is to my mind, really fruitful. It's the way to go, because are seeing now the importance of it. Recent proposal of a new transatlantic transborder data mechanism. So we need both sides of the pond need to get together, because there's a lot of stake here, not only from a commercial standpoint, but also from a human being standpoint.
Right. That's true. That's true. I think for obviously there's a commercial impetus because I think European Union is the US's biggest commerce partner. So they say they do, I think, $7 trillion a year in commerce, and they really want to make sure that gets there. But you can't ignore the human rights focus that we don't exactly have a foundation for in the US. And so my thing is, we're not going to be the same. So I don't think that we're going to ever have a GDPR in the US. That's just not going to happen, right? But we have to find a way to respect each other's, principles. So, in the US, I think our fine line is around free speech. And then I think in Europe is about privacy, privacy meaning, not sharing everything and being more responsible and being more transparent. So I think that they're going to eventually work this out. I'm interested to see how, this is going to be like a Shrimps 3 or something, probably a challenge there, but it's going to be really interesting. But I think one of the things that is happening in modern day that you touched on that I think is great is that in the digital age, we can see all these events happening in the different countries, and we can kind of pick and choose and look and see, hey, this is what works, this is what doesn't work. Maybe I'll take part of this law or that law and see how it works in my jurisdiction. So I think being able to have that is very helpful for people who are working on privacy legislation. I do want to touch a bit on AI. So I know that you are a policy fellow at the CAIDP, and I want to talk a little bit about what you see in the future as a challenge with privacy and AI. So you had already experienced, and you talked about earlier about how privacy sort of seeped into your work, with like digital transformation and all the technology and stuff. So I think AI is kind of the next level of that. So tell me about like your concerns with data as relates to AI and privacy.
Well, it is huge. I believe what we came to call as AI will challenge, at least to my mind, and others will challenge everything with regards to what we have learned from the way that privacy is safeguarded and regulated. The approach that we have used to safeguard privacy and cybersecurity to this point. So, and this is something that I have been given a lot of thought, not only with regards to what I read, what I read, and also within the work that I did at the Center for AI and Digital Policy. When you look how AI works, you see that it goes against all the principles that are the foundation of privacy to this point. Data minimization is contrary to the way AI and demands data. So the complete opposite of what data privacy has been crafted to at this point. So that means that the way we have dealt with to safeguard the rights of individuals with the typical notice, choice, consent, purpose limitation do not work as well in an AI and algorithmic environments. It's totally different. I will give you an example. You provide your consent for for centered purposes for a controller to use process your data. But using AI, they not only using the surface data to process for different aspects of their operation, but they are also mining all this data and getting a lot of information, probably that has not to anything to do with the purpose for which you have given your data in the first place. So you are defenseless in a sense because you are in the dark. You don't know for what your personal data will be used. It's being used by the controller. So in that sense, if you continue to approach data privacy within the control paradigm in which you have the ability to decide what information you can give or not, as has been, the typical classical definition of privacy from Alan Westing, which is, it's a very important part of the history of privacy. You will fail to provide the appropriate safeguards that people demand. People will not understand what use has been finally given to your personal data and what inferences controllers draw from all the data that you have given to them. So this is really a big challenge that we as a privacy professional have, because AI and all the different technologies, autonomous and algorithmic technologies associated with it, began to become ubiquitous, which is currently happening. And it's also not only are becoming ubiquitous, but also on a big scale. There's AI systems in a lot of places that you will never know that they are using this type of systems. But your fundamental rights will be at stake. How would you challenge not only to actually be aware that they are using these systems to process your data, but how you will challenge the inferences that these systems draw when these systems are, in a way, black boxes that even if you can break into it, that doesn't mean that you will understand what critical aspects, what are the inference that they are reach. And another problem is inferences are just that, are inferences, are not facts. We're risking a lot that if we not counter this, we will have a lot of systems reaching conclusions as inferences. And this goes to the main aspect of human dignity. You will be judged more not on what you are doing, or what you will do, but probably on your proclivities, on what are your tendencies, based on a statistical system which are not facts, which are in no way facts. So we have a very huge challenge on our hands as privacy professionals. There's a lot of scholarship right now trying to come up with a new fair information privacy principle for the digital and the AI age. Because with the current instruments that we have, we will not be able to provide the protection and safeguard that people demands moving forward.
I agree with that 1,000%. So if it were the world according to you, Roberto, and we did everything that you said, what would be your wish for privacy anywhere in the world, whether it be human, technology, regulation? What are your thoughts?
I wish that privacy remain a thing in the next century. So privacy is there. You come to terms with it. I despise that. This is something that we have to avoid. This is a very pernicious concept. A lot of commercial interests that people think that they're helpless, that they cannot avoid, but we can resist, and we should resist. because privacy can and should adapt, because privacy is not the same as was at the end of the 19th century, even during the 20th century. We need to adapt privacy to our current era. That's a given. But we cannot afford to renounce privacy, because something that goes to our very condition as humans. If we do not have privacy, we will not have those traits that make us human: our dignity, our liberty, our self-determination. At the end, democracy will become something of an illusion and life will not be something of value if you don't have a particular space for intimacy, for you to become yourself and share with others when you want it. So this is, at the end of the day, I want to think that privacy will remain not only a concept, but a fundamental human right during the next centuries.
Yeah. Wow. That's deep. Oh, wow. Thank you so much. I love your thought there. And you're not the only person that said this, which is 100 years. So, it's not just this year, and it's not just this election season, right? We're looking like very long game, long term on this, which is important. So, well, thank you so much for being on the show. This is great. I love your work. I'll continue to follow what you're doing, and I know people will love this episode as much as I do.
Thank you very much. It has been really a pleasure.
Thank you. Talk to you soon.
Likewise.